Thank you for tuning in today's seminar as part of the Law Week 2023 event series. My name is Keturah Sageman and I'm a senior partner at Nicholes Family Lawyers, a boutique family law firm with two offices, one in Melbourne and another in Geelong. I'm delighted to host today's seminar alongside my colleague Eve Dougherty, a senior associate, and I work closely with Eve at Nicholes Family Lawyers. The topic for today is how to protect yourself and your assets if your relationship ends. Before we begin, I would like to acknowledge the traditional custodians of the land upon which I stand. I extend my respect to the traditional custodians of the land upon which each of us are attending today's webinar. I pay my respects to elders past, present and emerging, and acknowledge any Aboriginal and Torres Strait Islander people who may be present. Today, Eve and I will discuss some common questions arising in the context of family asset protection, with a focus on de facto couples and relationship breakdown. We'll look at what is a de facto relationship, and if you're living together with a partner, when do you need to think about potential claims on your assets if the relationship breaks down? What are the risks you need to be wary of? And how do you protect your assets in the event of a separation? There is a growing feeling amongst the public that they need to either protect their assets when entering into relationships or receive a fair split of assets or financial support if the relationship ends. This is particularly so if they've repartnered and have already had a divorce or earlier relationship which ended in a costly dispute over property. As family lawyers, Eve and I provide our clients with advice as to their entitlements following separation, and we tailor our advice as to whether a binding financial agreement, such as a de facto prenup, is appropriate for them. The work we do in the field of family law extends well beyond divorce settlements, and we often advise clients at all stages of their relationships on how to protect their assets and liabilities in the event of a potential separation. The topic of family asset protection in the event of relationship breakdown can be stress-inducing and often difficult to broach with your partner. In light of that, we provide advice on the strategies and the legal process with options for our clients in order to protect their assets. This often involves risk mitigation and financial planning through the preparation of legal documents such as binding financial agreements, or as they're commonly called, prenups in the case of an upcoming wedding, or BFAs, and for de facto couples, they're also known as cohabitation agreements. Such binding financial agreements can be done before cohabitation, during the relationship, or after separation in the case of a de facto relationship. Eve and I will discuss several subtopics, including how the law treats de facto relationships in contrast to married couples in the context of asset division, when a relationship is considered a de facto relationship by law, the myth of assets being split 50-50, strategies to talk to your partner about signing a cohab agreement, and at what point in a relationship you can sign a cohab agreement. Toward the end of the webinar, you'll be able to ask us any questions that might arise. So now it's over to Eve. Thank you.
Thanks, Keturah. So I'm going to start off with one of the main questions that we get asked, and one that's not particularly extremely clear, is when does a relationship officially become a de facto relationship? So it's worth discussing the distinction between a casual relationship and a de facto relationship, which has legal implications. A de facto relationship is defined within the Family Law Act as a relationship between two people who are not legally married or related by family, who, having regard to all the circumstances of their relationship, are a couple living together on a genuine domestic basis. Often the standard of determining if a couple is de facto is the time spent cohabiting, with at least 2 years spent living together being the basis for a de facto relationship classification. However, if there are children or a substantial contribution to joint property, exceptions are made to this rule. That is, that you could be in a de facto relationship if you were living together for, say, 12 months, but paid a lump sum towards your partner's mortgage. This would be what we would consider a substantial contribution. Each case is examined individually, and each relationship is different. The following factors are considered by the court in determining whether a couple is in a de facto relationship. And these factors are not weighted as one being more important than another, and some or all might be present, or it's really up to the court in its discretionary nature to consider all of them and to consider whether or not the circumstances of your current relationship would fit into a de facto. So some of the things that the court will consider is how long the couple have been in a relationship, the nature and extent of their common residence, whether the relationship was sexual in nature, the extent to which the couple are financially dependent upon one another, the degree of their mutual commitment to a shared life, whether the relationship is registered in an Australian state or territory. Registering the relationship is an immediate trigger for de facto status. Property ownership and use, care and support of children, and the public aspects of the relationship, such as reputation.
Yeah, so there's certainly a lot more to de facto relationship than just living together by the sound of it. We'll now look at, does family law treat a de facto relationship any differently to a married couple when a relationship ends, and when a party can make a claim to divide assets and liabilities. In Australia, de facto and married couples are treated the same with respect to property division in the event of separation under the Family Law Act. However, there is a difference in time limits following separation with respect to filing for an alteration of property interests. A married couple has 12 months from the effective date of divorce to file, while a de facto couple has 2 years from the date of separation to file for an alteration of property interests. That's the time limit. If you file after that time, you may not be able to file without getting special leave, and sometimes you can't get that special leave. So just because you're in a de facto relationship does not mean that one party can make a claim on the other party's de facto partner's assets. The division of married couples' assets falls under Section 79 of the Family Law Act, and the division of a de facto couple's assets falls under Section 90 SM. Both sections take a similar approach to asset division. This involves what we know as a 4-step process. The first step is to firstly identify and value the parties' assets and debts, including all property and all liabilities, then determining the parties' respective contributions to those assets in the relationship, and that includes both financial and non-financial contributions, then considering the parties' future needs. And finally, the 4th step is to assess whether the proposed division would be just and equitable. So if it's a 50-50 or a 60-40 or a 70-30, would that division be just and equitable for both parties? In terms of how parties can divide their assets and liabilities, separated couples, both married and de facto, may either attempt to reach an agreement for division by way of negotiation. They might have a roundtable discussion in the kitchen to start with. They might decide to attend a mediation, or they could have a binding financial agreement prepared prior to their separation. The agreement can then be filed with the court by way of an application for consent orders if it's an agreement that you've reached with your partner and you've settled on the terms of the actual agreement. That can then be documented in the application for consent orders. If no agreement can be reached between the parties, then the alternative is to file an application with the court. That's the Federal Circuit and Family Court. In contested cases which cannot be resolved, the court will ultimately make a decision for the parties upon receiving all the evidence and testing it by way of a court hearing. Courts can make an order for the division of property that the separated couple owns, either jointly or separately. And this can include trusts and companies which form part of the asset pool. An order may also be made to split any Australian superannuation or it may require one party to pay the other spousal maintenance in the appropriate case. Both de facto married couples can also enter into binding financial agreements during a relationship, as we've mentioned, to determine the distribution of the asset pool in the event that the relationship ends. Prenups can be an excellent option, similar to a contract, to remove uncertainty of the division of the asset pool in the event of separation. This can be particularly comforting when one couple has substantially greater assets. However, we will examine this more closely later in the seminar.
Thanks, Keturah. And talking on the binding financial agreements or prenups, it's really important that they are drafted by experienced family lawyers and that you receive proper legal advice from a family lawyer. When we're talking about de facto relationships, there's a very common misconception that comes around, which is it true that when a relationship ends, de facto or a marriage, that all assets are split 50-50? This is one that Keturah and I often hear, but it isn't correct. Property division in Australia is not based on any mathematical formula. And if there is to be a division of assets, in some cases there isn't a division, but if there is to be one, the court considers multiple factors to ensure that the division is just and equitable for both parties. There is no automatic presumption that the parties' assets will be split evenly following separation. This is because no two relationships are the same, and the division of property must be tailored to recognise the contributions of the parties, their future needs, and what would be just and equitable. This myth potentially comes from the belief that if a person puts in a certain amount of money into the relationship, that they are guaranteed to receive all that money back once the relationship dissolves. Family law is not about compensating for any financial loss. The court will certainly consider the fact that a person has contributed financially to the relationship, including what they had prior to the commencement of the relationship. However, the court will also have to have regard to any non-financial contributions, such as looking after children, to the marriage and managing the household. So those contributions will not be ignored. For example, a common misconception which ties to the 50-50 myth often involves ex-couples where the husband was the primary wage earner and the wife cared for the children. Often people assume in this relationship dynamic that the primary wage earner would receive the majority of assets upon separation. And you often hear things like, well, I worked the most. However, in this scenario, the court would have regard to the mother's contribution, which are significant contributions in that she has birthed and raised children, has been managing the household generally. And the court might also take into account that during this relationship, in the de facto husband's case, he was able to increase his earning potential, whilst the de facto wife might have less earning potential. And this is either due to the qualifications that she has. She might not have had the time to seek qualifications or to improve upon her career because she's been caring for the children and supervising the children, which takes time. As a result, the court will consider the future needs of the de facto wife, and they might make an adjustment of the distribution of the asset pool in her favour. Sometimes this might be called, an adjustment, and it can be on a percentage basis. So the court will take a holistic view of people's contributions to their relationship, both financial and non-financial, when dividing the asset pool. That being said, it's important to keep in mind that the court does make decisions on a case-by-case basis, and this depends on the facts. So whilst you might know a friend or a neighbour or a family member that received a different settlement outcome than you, that's because their relationship is different to yours. So some asset pools are split between ex-partners at a 50-50 percentage. Others might be 60-40 percentage or 70-30. And in rare but some circumstances, splits could even be 95% to one party and 5% to another. The law sets out the various factors to be considered when calculating how assets should be distributed following the breakdown of a marriage, or in this case, a de facto relationship. And these factors include the financial and non-financial contributions made by each person in their relationship, such as wages, gifts, inheritances, looking after children, renovations, property maintenance, utilising special skills. The future needs of each person includes a number of factors, such as your future earning capacity, your health, your age, who will look after any children to the relationship, and that's children under 18 years of age. The division of property following divorce of a well-known artist, Brett Whiteley, in the 90s is a good example of non-financial contributions. In this case, the court recognised the indirect financial contributions to the property. They're made by the wife. Wendy, Brett's wife, was found to have made notable contributions to his artwork earnings by providing him with artistic inspiration and intellectual critique during the course of their relationship. She was also his model, business support, homemaker, and primary carer for the children. Having given weight to these factors, the court assessed the contribution to be 70-30 in favour of Brett. Also having regard to him being an artist of repute with special skills which resulted in their multi-million-dollar asset pool. Each party's individual set of circumstances is unique, and the court will give weight to each party's contributions, both initially, so that is the start of the relationship, throughout the relationship, and even after separation. Finally, it's worth noting that the court will only make orders for property settlement when it is satisfied that it is just and equitable to make that order. The court will not give effect to drafted consent orders where the split is substantially incongruent with the contributions of the parties, for instance.
Yes, it's always different with different couples and the length of time they live together. So that's how it works. So we'll now look at what is the best way to talk with my partner about signing an asset protection prenup, also known as a binding financial agreement. This is a question that we as family lawyers hear a lot. Before outlining the best ways to approach a conversation about signing a prenup, it's appropriate to outline what is involved with a binding financial agreement. So binding financial agreements effectively allow parties to contract out of the general provisions of the Family Law Act concerning property and financial matters. They effectively enable parties to quarantine their assets from the asset pool available for division in the event of a relationship breakdown. So for example, if you've had a large inheritance that you got on your side of the family and you want to protect that inheritance, it is possible to quarantine that inheritance by way of a binding financial agreement. So it can be an excellent asset protection tool and aid in the planning for the future to avoid any unintended property disputes and the emotional and toll and expense of property proceedings and costly legal fees. At Nicholes Family Lawyers, we often see prenups being used to enable the preservation of assets for purposes such as enabling consistency with inheritance expectations, preserving particular property interests such as businesses, family trusts, or significant asset portfolios. Also, we find that sometimes we want to have an allocation of weight to a higher income earner or the party bringing in significantly more property to the relationship, having that recognised and documented in a contract, which effectively means you're deciding yourselves how the assets are going to be split to avoid a future dispute. Some people who may benefit from a prenup or cohabitation agreement include those entering into second or subsequent marriages or relationships, couples who want to protect their assets that they've put together, that they've brought into the relationship, and financial agreements which acknowledge one party's financial interests regardless of whose name the property was put in. So it is quite an effective tool, particularly if you've been through a messy divorce or you've been through a messy separation and you've managed to build up an asset pool and you do want to protect that into the future with your second relationship. So having outlined what a binding financial agreement is, we understand that there is still a stigma surrounding prenups and what they indicate about a couple's relationship. Some people think that prenups or cohab agreements ruin the romance of a relationship and send a message to family and friends that the union is destined to break down. However, the reality is, in today's day and age, that in many instances, a complex or protracted and costly property dispute could have been prevented with a prenup or cohabitation agreement. It's a practical measure to reduce the uncertainty of the division of asset pools at separation and to allow parties to reach agreement between themselves without interference by any court. Relationships do often break down, and if you can approach the prenup conversation with your partner with openness, maturity, and respect, there's no reason why you can't secure your assets while also maintaining that relationship. The best way to approach such a conversation is to be clear and straightforward and open to compromise. Be open and honest with your partner about what you're trying to achieve in forming such an agreement, and be prepared to discuss any questions or concerns they may have. It's also good to start these conversations early. So it can happen before you've even thought about separation, during the relationship, in contemplation of what happens if you do separate in the future. Be open to suggestions about how you would like to divvy up assets, what you would like to include in separate assets and what you'd like to include as joint, and have an open discussion about the terms of the agreement. So a good way to look at these difficult discussions is to view them as a relationship insurance, a practical way of preserving your assets. It's worth revisiting the contents of your cohabitation agreement or BFA over the duration of your relationship. This is if you're doing one as in the event of a relationship breakdown, as they can be set aside if there's a material change in circumstances concerning children since the making of the agreement. There are strict requirements when drafting and finalising a binding financial agreement, and it's essential that both parties receive independent legal advice from a family lawyer with certificates of such advice. If either party does not enter into the binding financial agreement out of their own free will, or if it's under duress, the agreement may be set aside by the court.
Thanks, Keturah. So often we get asked, can I sign a prenup at any stage of my relationship, at the start, during, or immediately after? And that's a really good question, because they don't have to be entered into at any particular stage. They can be entered into at any stage of the relationship, be that before cohabitating together, before marriage, during the marriage, or after separation. And they can be entered into by de facto relationships, people in de facto relationships at any time. That might be before they move in together, during the de facto relationship, or after their separation. As advised, it is important to keep in mind that the requirement of formalising a prenup is in both parties receive independent legal advice prior to entering into that agreement, and it has to be from a separate solicitor. The prenup will contain a certificate that is signed by each party's solicitor, certifying that they've advised their client on the prenup, their entitlements, and the advantages and disadvantages of entering into an agreement. Once completed, the parties should revisit the agreement on occasion, as enforceability lapses if there's been the material change in circumstances since that initial agreement. In particular, if the parties have a child or receive an unexpected windfall that was not accounted for in the original agreement. It's prudent to mitigate the risk of a binding financial agreement lapsing, and we recommend taking a precautionary approach by revisiting the agreement regularly, taking steps to have a new binding financial agreement drafted, once again with independent legal advice, if there's the material change in circumstances. That's why it's worth noting that a binding financial agreement can be made at any point in the relationship. Now, it's now over to everyone participating today. Are there any questions from the audience? If you'd like to enter them into the chat box, or you can unmute yourself and ask. But Keturah, we do have one question, which is quite an interesting one. So it's asking about how family violence factors into any property settlement, or division of property settlement, and what factors need to be present?
Yes, that's an interesting question. Family violence, I mean, of itself, does not have a direct impact on property settlement. There is, however, a class of cases, they're known as Kennan cases in the family court, where there is a recognition in some cases of severe, if you could call it that, severe family violence, and where it's actually had an impact on that party's ability to contribute. You know, they might have been injured in the course of that violent incident and made it harder to make contributions. There have been cases which do recognise that can give rise to an adjustment in favour of the party who's been the subject of family violence. But it's interesting that you raise that question, because there is reforms coming through to the Family Law Act, and they're in a bill that's a draft bill with the Parliament at the moment about amendments to the Family Law Act, and they're looking at codifying some of these concepts, particularly in relation to family violence and recognition of that. So in the years to come, 2024, look out, because there could be some amendments to the Family Law Act that do have a much more tailored approach in terms of recognising some of these things that do impact on many relationships and do make it considerably harder to, you know, get on in later life and to you know, stand up and on your own 2 feet and restart when you've had a breakdown. Eve, was there anything you wanted to add to that?
No, I think that's a really good summary, Keturah, and it's good to see that the law is moving forward and taking into account the different experiences of people. We do have a second question, which is, can there be 2 relationships happening at one time? Now, with this question, there's 2 parts to it, but that question, can there be 2 relationships happening at one time? If you're talking about a current relationship, then yes, you can have a couple that are married, and one or both of those people in the marriage can have different de facto relationship with someone else. There can be a married couple that have a de facto relationship with another person. You could have multiple de facto relationships as well, but it all comes down to whether or not, under the Family Law Act, each relationship is going to satisfy the criteria that we talked about. So the intention of the parties, whether or not you're living together, whether or not you have a shared residence, all of those bits and pieces that we spoke about at the start. The second part to this question is an example. So if someone is married for 5 years, but they've been separated for 8 years, but not divorced, and then they have a new de facto relationship of 18 months. So in that scenario, this person would have potentially have a de facto relationship. With 18 months there, it depends on all the other different factors, because the time frame of 18 months may not be insufficient in itself, but there may have been substantial contributions or children, and that's something you would need to look at. And that someone is still married, that doesn't stop them having a de facto relationship, but being married to someone and not divorced can create liability or issue there in terms of a property settlement, can't it, Keturah?
Oh, absolutely. And in fact, even I have had an experience with a court case where there was what you might call a double life, or two relationships, 2 de facto so-called relationships happening at the same time. And it did go to court to actually test whether or not one of the relationships was in fact a de facto relationship. And we really did have to know our stuff. And obviously we did actually get a win in that case. And it was about, you know, determining whether or not there was a de facto relationship between this particular couple, whilst one of them was carrying on a de facto relationship with somebody else. Because obviously, once you get over the hurdle of proving a de facto relationship, then the next step is, can a claim be made for a property adjustment? And that, you know, that's often where the concern lies. So yes, it's certainly something that does happen.
Certainly. And yeah, sorry, Keturah, if someone is married and not divorced, but in another relationship with someone else, it is really important that the marriage has had a property settlement. Because if you haven't had a property settlement and you remain married to someone, you could, in certain circumstances, end up having a property settlement with that person down the track. So these are things to bear in mind, particularly if you have assets that are growing in value, or your income is growing and your savings are growing. These are things to think about.
Absolutely. I think there's a bit more to that question. Eve, I don't know if you want to have a look at that as well.
Yeah, so whether or not an ex-partner is able to access the new de facto partner's assets, that one would depend on how the assets are held. So if they're assets of the person that's married and in a de facto relationship, or if they're assets in the de facto person's name. But it also comes down to just because something is held in someone's name doesn't mean that someone doesn't own an interest in it. So it's really important that these scenarios come in and have proper legal advice. This is just an information session, but if there's something that you would like to come and discuss, please, come in and do that, so we can talk about what the assets are, how they are required in the relationship, either relationship, and whether or not they're assets that would be potentially included in any property settlement.
Yes, that's exactly right. And I think, as we have emphasised, each case is a bit different, and sometimes it may be that you're in a de facto relationship, but you're not entitled to a property claim, or you have to keep the assets that you came in with, and that's where it stands. So we're happy to have those conferences and advise clients on their specific circumstances. Any more?
If there's no further questions, that brings us to the end of our presentation today. I hope that you found this a useful discussion and that you all leave here today with some takeaways. Asset protection and prenups are complicated topics, and ones that come with the emotional factors. And in the case of prenups, occasionally they come with stigma. Each of you have joined today's webinar for many different reasons, whether that be out of a general interest or because you're considering getting a prenup, or you want to deepen your understanding of asset protection, or you want to educate yourself about financial options. Whatever your reason is, and regardless of where you're at and who you are and what type of relationship you're in, asset protection and financial settlements following relationship breakdowns are really important topics to understand.
That's right. Thanks, Eve. And you're certainly more than welcome to contact our offices should you have any questions following today's webinar, or should you wish to seek family law advice. So thank you for your attendance, and we'll sign off there.